Circuit. Judge Harris and I are also happy to welcome Judge Haynes here to provide us her able assistance today as well. We're going to hear two cases today. The first is Coleman versus North Carolina Department of Public Safety. So whenever you're ready, counsel.
Good morning. May it please the court. My name is Kramer Lewis, and I represent the plaintiff appellant in this case, the estate of Devontae Coleman. There are two issues before the court. One, whether the district court erred in granting summary judgment to all of the individual defendants on Devontae's Eighth Amendment claim when material fact disputes remain with respect to the conditions of confinement that Devontae was exposed to while he was in the hospital on his deathbed. And two, whether the district court erred in failing to consider or rule on the direct constitutional claim under the North Carolina Constitution that Devontae's estate brought against NCDPS.
Are you talking about the conversion and obstruction of justice claim that you're bringing?
Yes,
today?
Your Honor.
Where did you argue that below, the argument you're making here?
We argued it in our brief. Below in the summary judgment brief. We also argued it in at the hearing for summary judgment, and we argued it. We brought that claim in our complaint, and in the complaint it was under Section 1 or Article 1, Section 27 of the North Carolina Constitution.
So where is it in your complaint? What count?
I'm not sure the count off of the top of my head, but it's the North Carolina constitutional claim.
Do you have the complaint anywhere with you today?
Yes.
So, I mean, I'll let Judge Harris finish, but maybe you can find that then and when you get back up here. But go ahead.
I mean, you do have the count for a North Carolina constitutional violation, but it is not about conversion or obstruction. It's about the deprivation of the necessities of life. It's basically the conditions of confinement claim, so I don't really see a claim for a North Carolina constitutional violation based on conversion or obstruction. So given that you're faulting the district court for not reaching this claim, I think it is only fair to point out it's not in your complaint.
Yes, Your Honor, that is fair to point out. I would answer that our complaint has, again, that Section 1, or Article 1, Section 27, under the North Carolina Constitution, and that the obstruction and the conversion claims are also in the complaint, and it's all incorporated by reference. And then at summary judgment, we argued that to the extent that those claims can't go forward because of the function of sovereign immunity on its own, that under Courtroom, we should be able to bring those claims directly against NCDPS.
Are you saying that your obstruction and conversion claims are somewhere else in your complaint, separate from your complaint about Article 1, Section 27, and that we have to just read the whole thing and piece it together to find that claim in your complaint?
Yes, Your Honor. To an extent, it's from the incorporation, and then
With all of that effort, why isn't that argument waived if you have to jump, if the court, particularly the district court, would have had to jump through all the hurdles you just recounted in order to even find that claim?
Because that was in our kind of complaint, and then the facts developed throughout discovery.
But then you're supposed to amend your complaint. I mean, we've said on several occasions you can't amend your complaint by arguing something new at summary judgment, and I'm bracketing whether this was argued at summary judgment, but I mean, that's what amendments are for.
Understood, Your Honors. If it's all right, I would turn to the Eighth Amendment claim.
Please do.
Yes, Devontae was palpably deprived of his constitutional rights under the Eighth Amendment. Under the totality of the circumstances, he was deprived of identifiable human needs, and that led to a serious emotional injury, or at least the substantial evidence of a possible emotional injury. And there are fact disputes kind of underlying.
Well, what's your best authority to support that the totality of the circumstances here amounted to the level of extremeness required for an Eighth Amendment violation?
Our best authority is Lafott, but in terms of the question about what is how does the totality of the circumstances play in, I think it's really important to understand what are these circumstances, and they are that Devontae was in the hospital during the summer of 2018. He's got this fatal, he's terminally ill with this rare fungal infection. It's caused his head to swell. He's kind of disfigured. His eye is swollen shut. He's got severe facial pain, headaches, nausea, kidney injuries ultimately, and anemia. And under these circumstances, the argument is that when a prisoner is under these kind of circumstances, for the guards in his room to force him to urinate in a cup while he's still chained to the bed in front of his family, in front of mixed company guards, while there's a restroom just 2 to 3 feet away inside of this private room, it's a private restroom, that this deprives him of his basic human needs. And the way that it plays into Lafott, in that case, that was out of North Carolina, I believe in the 80s, and it's a federal Bivens claim. And that you've got a prisoner that's in a wheelchair who has to kind of undergo these sort of embarrassing procedures to use the restroom. And this goes on for a while, and the facilities there didn't quite meet his needs. And he's asking, hey, can I have better facilities? And they're not really doing anything. And the court really found that he was particularly susceptible, right, to this embarrassing procedures to have to try to use the restroom. And they found that it was an Eighth Amendment violation, particularly under the circumstances where there were practical solutions that were available, and they were ignored out of mere convenience or apathy. In this case, you've got almost really an even worse circumstance, because these aren't facilities that are just bad. He's in a hospital, and there is access to a restroom right there. Where the kind of apathy or wanton infliction of pain comes in is he's asking, hey, I'd like to urinate. Can I go to the restroom that's 2 to 3 feet away? And the response is, no, you have to stay chained to the bed, and we'll hand you a cup, and you need to try to urinate in this cup, despite the fact that your head's swollen, you're in all of this pain, undergoing all of this terminal illness. And your mom and dad are in the room, and there's female guards sometimes in the room and male guards. So to really bring Lafott into this circumstance would be, later on in Lafott, they tried to fix a restroom by taking out a wall of a stall so that he could use it better under his circumstances. And the court explicitly said that still doesn't really do it, because he's now more exposed, and guards, or not guards, but other prisoners could see him undergoing those embarrassing procedures. Well, to bring Lafott to this case, while he's in that stall, not just other prisoners, put his mom and dad in the room, and put mixed company guards in the room while he's trying to undergo these procedures. And so that is where this kind of wantonness comes in. And that's also to the qualified immunity portion of it, in addition to this objective severity. Lafott, for those reasons, the reasoning of it, as well as what the court really took issue with, should have put these guards on notice that what they were doing was wanton infliction of severe emotional pain. There's been this kind of question about, well, shouldn't we need expert testimony to demonstrate that this was a severe emotional injury? And I think that was kind of a clever framing of the issue below by the defendants, and I think the district court kind of latched onto this sort of straw man of, are you saying that he would have died less quickly had this not been done to him? And that's not the injury that we're alleging at all. We're alleging this humiliation and degrading sort of behavior that's being done to Devontae by the guards while he's in the room. And that sort of injury, understanding that emotionally palpable injury, is in the purview of a jury. And this court has spoken twice on this issue, at least with respect to severity and expert testimony. This court has said in Jones and Cento that you don't need expert testimony for when an individual isn't given insulin or when they're having to come into contact with
In
feces.
addition to having to use the urinal in the hospital bed, weren't there other things adding to the totality of the circumstances, in your view, that create an Eighth Amendment violation?
With respect to the totality of the circumstances, what Wilson tells us and other Supreme Court precedent tells us is it's kind of a funnel effect, right? It's not like you stack, and eventually the dam breaks. You can have all these different kinds of circumstances, but they all have to go down to depriving someone of a identifiable human need. And below, yeah, we put in a lot of different circumstances, and I think that adds to kind of the emotional situation, right, where he's not able to go out and
Would you like to recount those now, the other circumstances? I mean, it's the urinal, it's the being handcuffed to the bed, it's the food situation.
Yes, Your Honor.
Lack of visitors.
That's right. It's lack of visitors. It's not being able to go outside. It's not being able to use the restroom when he's asking to, and it's available there for him. It is his family not being able to kind of hold his hand or anything whenever he is going through this terminal illness. But the way that, if we're looking at the case law, I think the way that everything goes down to depriving him of an identifiable.
Do you know if he had been in a prison hospital setting, like at Butner or somewhere, would he have been able to have visitors and have people hold his hand and all of that stuff, or no?
Your Honor, I do not know, but I do know that it's not a constitutional violation to deny visitors, which is why I want to focus on the circumstances of he is terminally ill, and the combination of that circumstance with him asking, hey, I need to urinate, can I go to the restroom, and them saying, no, you need to urinate in this humiliating way. That is the clear, identifiable human need that the circumstances combine to deprive him of in that sort of funnel fashion.
Mm-hmm. You talked about the district court making certain findings of fact or not making inferences in your favor. Do you want to give us an example of that?
Yes, with respect to the food being taken away, if he can't eat it quickly enough while he's chained to the bed and undergoing this illness. Derek Coleman testified that this was happening at least once a week when he's in the room and seeing his son. The district court took that as the kind of top and all that could have been inferred, right? They stopped the inference there. All that could be happening is he's losing this food at most once a week. If you're taking the inference in the light most favorable to the non-movement, Devontae, that is not where the inference stops, it's where it starts. The inference is that, not that they're doing less things that are humiliating and degrading and hurting Devontae when his dad's not there, but that they're doing more, and that the father's not necessarily seeing all of it. With respect to the urination, several guards testified, the guards who were identified in affidavits and in testimony by the Colemans, who were supposed to be doing this bathroom deprivation, those folks, several of them denied outright that they had done it. One just didn't deny it. Another said that, well, yeah, maybe I could have done it. And to that point, the one that said she could have, she kind of contradicted and went back and forth and said, hey, that would be inappropriate to do, which one shows subjectively she was aware that this was bad. So we have this fact dispute as to what even happened in the room, and it's kind of just being glossed over or resolved with respect to the urination.
So can I ask you a question? The district court found that a lot of this was a matter of policy, that the, I can't remember the name of the entity, but the entity has these policies, the guards are following the policies. If that is right, doesn't it become difficult to argue that the individual guards had the requisite sort of deliberate indifference if they're just following policy?
Yes, Your Honor, and that is a really great question. I'm very glad you asked it. There is an underlying fact dispute as to what the policy is with the urinating while chained to the bed, even though there's a bathroom right there. The warden at the time, Thomas, was deposed, and he said, if I knew this was going on, I would investigate it and try to take corrective action. The guards were variously saying, no, this is up to our discretion. It's pretty much saying there's not like a policy that we're following on this. I see that my time is up now, so I will just conclude that we'd ask that the court reverse and remand with respect to the Eighth Amendment claim.
All right, thank you, Mr. Lewis, and you have some time in rebuttal as well. Mr. Williams?
May it please the court, my name is Alex Williams, and I represent the defendant appellees. It is tragic that plaintiff contracted this infection and he subsequently passed away. But we're not here about how he got sick or what kind of medical treatment he got. Ultimately, this is a conditions of confinement case, and I call it with a tag-along, and that tag-along being a state constitutional claim. Plaintiff cannot satisfy either claim.
Well, did plaintiff waive the obstruction and conversion claim?
Yeah, I believe he did, yes. The answer is yes. And so he did not appeal the dismissal of, there were separate claims for obstruction of justice and conversion. He did not appeal either one of those. What he's trying to do is now morph this state constitutional claim that was previously based on conditions of confinement into a newly alleged conversion or obstruction of justice claim. And the case law is very clear that you're not allowed to switch horses midstream like that. And so I do not believe that plaintiff has that claim available to him right now. As Your Honor mentioned, Judge Harris, he should have amended his complaint to have included that if that's what he wanted to argue. The case law is very clear that you're not allowed to amend during summary judgment briefing or summary judgment oral argument, and that's effectively what he's trying to do.
Counsel, before we leave obstruction, I mean, what on earth happened? All the shift records just go missing? Like the exact records the plaintiff would need to kind of prove subjective intent on the part of individual officers, they all disappear in the middle of the litigation? I mean, have you guys figured out what went wrong?
So first off, let me correct part of that. Not all of them went missing.
But many, many days worth.
Yes, many, many days worth did.
And separate, there wasn't just one set of records, it's two set of records for the same days, and those records were all kept in different locations, right?
I don't know that they were ultimately kept in different locations. They would have started at the hospital logs, and then they would have made their way back to Central Prison where they would have been kept probably in the same area as the shift narratives.
But there were the shift narratives and the hospital logs, and both went missing for the same number of days. So it looked like there were two sets of logs that were then missing.
I don't dispute that there are two sets of logs. I'd have to go back and compare whether they're the exact same days that went missing. There might have been some overlap, but I don't think that if they're being kept in the same place at Central Prison, that actually kind of makes sense to me, that if you start missing one set and they're kept in the same place, you're probably going to be missing the same set.
These are paper records?
Yes, Your Honor.
Okay.
Yes,
So
they
what
are.
happened? Why? I mean, is there some explanation? I mean, I find it alarming. I don't know why the district court would not have made an adverse inference against your client, given the lack of these records, and why would that have not been appropriate?
Your Honor, for a few reasons. Number one, I think for any adverse inference, you have to show some sort of intent. And that's the exact problem that the district court had with these two claims. Number one, these are distinct claims that he alleged, I believe, in counts 6 and 7, versus his state constitutional claim is a distinct other claim that he's alleging, I think, in count 5 or something like that. And when the district court looked at this, it said, hey, you've got to show intent to satisfy these claims, but even if you're talking about an adverse inference, you would still have to show intent. And he cannot pinpoint who had these records, what happened to these records. There's nothing that can be tied down for what happened to these
But
records.
Yeah.
how is he supposed to be able to do that? He's busy dying, chained to his hospital bed when all the records go missing.
And you couldn't pinpoint it a few minutes ago when Judge Haynes was asking you about it. How's he supposed to figure it out?
Well, Your Honor, I think he had months upon months during discovery to try to pin this down, and he did. And he had all these depositions, and the warden and everybody else said, hey, I don't know what happened to these records. I wish we had them too. But the records that even we did produce, plaintiffs still did not make use of those records. And what I mean by that is, there were shift narratives, there were hospital logs that we produced, and there were a lot more guards that were taking care of Devontae. Those guards were not named in this lawsuit. So even the records that we did produce, he didn't take advantage of them. And the records that we did produce show that we're not depriving him of any basic human needs. They show that he was getting up and walking. They show that his urinal was being emptied. They show that he was actually getting up and using the restroom. They show that he's getting this medical care. This is not the level of
So he wasn't required to use the urinal all the time?
No, Your Honor. The hospital logs show that he was allowed to get up and use the restroom. And so when I look at this case, and I look at this case through an Eighth Amendment lens, we have to see an extreme deprivation. He's being kept at two of North Carolina's best hospitals. How can we have an extreme deprivation when he is at Duke University's hospital, one of the best in the country, and a hospital, Rex Hospital, which is part of the UNC healthcare system?
But that's not their claim. Their claim isn't related to the medical care that he received. Their claim's related to the treatment he received at the hands of the guards, irrespective of the medical care he received.
Yes, but I still just find it hard to believe that you're going to have that extreme deprivation in this hospital setting. Because what we ultimately see, and we don't see an extreme deprivation, because what we ultimately see is he's complaining about having to use a urinal. He's not saying he didn't get to go to the bathroom. He's not saying he didn't get to relieve his bodily functions. He's just saying he didn't get to do it in the way that he wanted to do it. He's not saying he didn't get food. In fact, the hospital records show that he was getting food. The medical records actually show that he didn't want food. He had a lack of appetite. And lastly, the hospital records and the hospital logs, they were showing that he was sleeping. So he's not getting that deprivation of rest. He may not be getting the rest that he wanted at the times that he wanted, but that is nothing more than routine discomfort. And the Supreme Court has...
Isn't there a medical facility at Butner in North Carolina?
That is a federal facility, but yes, Your Honor, there is. And there's also within the North Carolina prison system, Central Prison has a medical facility.
All right.
But in these contexts, he's not having these Eighth Amendment violations. He's getting food, he's getting rest, he's getting to relieve his bodily functions. He's just not able to do it in his desired manner. And that's what this whole lawsuit is about, is he forgets that he was still a prisoner.
And that's sort of my point. If he had been in one of the state prison medical facilities, people couldn't have brought him food from the outside, and he would have been still in a confined, he would have been, well, maybe he wouldn't have needed to be handcuffed because he would have been in a prison facility. So it might have been worse had he been in a prison facility than being at Duke.
That's correct, Your Honor. Arguably, I think it would have been worse. I mean, let's be honest, Rex Hospital probably has, I've been to Rex Hospital, I've had their food, I can tell you their food is probably way better than prison food. And so he was getting some sort of a benefit in being at the hospital. There were certain things that he probably would not have gotten had he been at one of these prison medical facilities. So we just don't see this level of a deprivation under the Eighth Amendment that he talks about. So I don't think that he can satisfy the objective requirement under an Eighth Amendment claim for those reasons. But then,
Can I ask you a question before you move on
Yes.
to that? There are a couple instances in which the district court and plaintiff cites one in which regarding, the father testifying about finishing meals, and he was only there once a week, and so the inference that the district court made was that it could have only occurred at most once a week. That seems to me to be an improper inference. It should have gone the other way, that if he saw that every time that he was there, the dad, then the inference should have been that when he wasn't there, that was the same thing that was occurring. Do you think that that's a proper inference that the district court made in that instance?
I don't think that's proper when we also consider the medical records that were submitted. Because the medical records and the hospital logs that we did submit show that he was getting these meals. They mentioned nothing about him not getting the nourishment that he needed. And I think ultimately, let's say even if we draw that inference, let's say his meals were rushed every single time, we still do not know the duration that he's talking about for the rushing. Does he consider an hour to be rushed? Is 10 minutes rushed? We don't know that because he didn't testify to any of that. And so he's just saying that there were these rushed meals, but we don't know the extent and the frequency of it because there's no evidence to it. Quite frankly, the evidence is in our favor that shows that the medical records show he didn't want to eat. He had a lack of appetite because of his condition, but that he was given food and that they were encouraging him to take food. The hospital logs show when the food was taken, when the food arrived, and it shows that it arrived every single day.
But again, I hate to keep coming back to this, but I'm not relying on the hospital logs we have when some of them have gone missing makes me a little uncomfortable. Do you see why this is somewhat concerning? Like, I'm not saying this happened, but for all we know, someone pulled out the bad days, those are the ones that are missing, and left us with the good days. So how much can we rely on a set of records that is incomplete, and it's incomplete because of something that happened at the state's hands?
Well, I think when we're talking about drawing inferences in the light most favorable to the plaintiff, which is what Judge Haynes had asked about, I think you have to consider the evidence that is there. And I think you do have some evidence.
It's like a curated set of hospital records. I'm not
The hospital logs, Your Honor, they may be missing and they may be incomplete. The medical records are not. Those are complete. And the medical records do show that he was receiving food, he was being encouraged to eat food, but that he had a lack of appetite. And so I don't
What
think
did you say was incomplete? I'm sorry.
the hospital logs are different than the medical records. And so the hospital logs are the prison-created logs by the guards, wherein the medical records would have been by nurses or doctors or whoever. And so the medical records actually show that he was receiving food, but that he had a lack of appetite and that he didn't want to eat. And so I still don't think, even if we take that inference and we construe it in the light most favorable to plaintiff and say that his meals were quote-unquote rushed, we still don't know what that means. And we still don't know whether that's 5 minutes, 15 minutes, 30 minutes, an hour. The simple fact of the matter is plaintiff failed to satisfy that element to show that it was an extreme deprivation, which is what's required. And so I still don't think he can satisfy that objective element under any standard here. But then, even if he could satisfy that, he still cannot satisfy the subjective element. Because again, he cannot identify which guard did which action.
And that's because the logs are missing, in part. The logs do show, don't they, which, the hospital logs, which guard was there at different
That's correct, Your
times.
Honor, they would. And even the logs that we produced, they didn't make any use of them. And Devontae's parents were there. They witnessed the individuals who were doing this. The individuals have a name tag on their chest. They didn't take down any information. They didn't do anything.
The parents might have been somewhat distracted, right, because they had to tend to their dying son, so maybe they weren't like busy writing down names.
Quite the
Quite the contrary. Go ahead.
In this case, I think that's quite the contrary because they quickly hired an attorney. Their attorney was actively working while Devontae was still in the hospital. They knew that they needed to be maintaining these things. They took the steps to maintain those things. They just didn't maintain those names. And I think that in this particular case, Mr. DeVore, their attorney who's sitting right behind me, he was there. I don't remember exactly at what time period, but months before Devontae died, Mr. DeVore was there. And they should have known that they need to know each individual who was doing these things.
But in discovery, they asked you for the names, and my review of the record suggests that you all didn't initially, you resisted providing them the names until their clients sat down and looked at the videos and put names and faces together. I mean, when they initially served the preservation request and asked for the names, that you didn't turn over records until the lawsuit was filed, till discovery was requested, right? There was delay.
You're right, in the records were not produced until the lawsuit was filed. I think these records are confidential under North Carolina law, so I don't think they were entitled to them until the point of a lawsuit being filed and discovery request being served. And so we did produce what we had at that point in time, and so even
Why wouldn't all of the guards been, you could have looked at the list of the guards, and they should have all been listed in your disclosures as individuals with possible information. Why weren't the guards listed right from the outset, and every guard that interacted with him listed in your initial disclosures?
Your Honor, I don't know that they weren't. A lot of times, well, I don't know the answer to that because I don't have the initial disclosures in front of me. I wasn't involved when the initial disclosures were done, but I don't know that they weren't. A lot of times what we do is we identify individuals saying, hey, we're producing to you these documents. We're going to identify the individuals produced within these documents or identified within these documents. And so I still think that through discovery, the documents that we did produce to them, they still did not utilize. There are multiple guards that were not named as a defendant in this lawsuit. And they had them. They had the hospital records to show that they were the ones that were actively taking care of Devontae, and they didn't do anything about it. They just kind of haphazardly named a bunch of guards, and they cannot tell you which one did each thing. And so I don't think that they can satisfy the subjective element because they can't show that these guards had that required knowledge that it was being a constitutional violation.
Can I ask you a question about that? The district court seems to have reasoned that if the defendants are following department policy, then they can't be deliberately indifferent. And why is that so? I mean, I would think that you could have a department policy that is, perfectly fine in the vast run of cases, but you could still know that in a particular application, it's causing a risk of serious harm.
Your Honor, I think that the guards, rightfully so, operate with the idea that these policies are put in place not only for the guards' protection, but also for the inmates' protection a lot of times. And so I think by following those policies, I think that the guards had a reasonable expectation that there was no risk of harm to Devontae. And when we look at this and what I heard plaintiffs say, they're really focused on, they've kind of abandoned a lot of this as far as the policies go. They seem to only be focusing, I think I heard him say that they're focusing on the humiliation associated with the urinal. And that seems to be the focus of what their argument is today. With that particular policy in mind, the testimony, if I remember it correctly, was that it depended on how many guards were present and how many inmates were present at the hospital. And that the idea was that they wanted there to be 2 guards present when an inmate is released from his shackles and allowed to get up out of his bed and go somewhere else. And so the evidence, I think, if I remember correctly, said that there were times where Devontae didn't want to get up. And that makes sense. He's really, really sick. That is consistent with a lot of other hospital patients. They don't want to get up. They choose voluntarily to use that urinal. But there were probably other times where maybe he did want to get up, but there was only 1 guard present. And so they said that they would have to wait for that second guard to get there.
Would you like to respond to opposing counsel's argument that our LaFont opinion supports his argument?
Your Honor, I think LaFont is very, very different. LaFont, I think, was in a prison context, not in a hospital context, number one. LaFont, I think, involved a very different situation with an inmate. That particular inmate, they did not have a toilet that would satisfy that particular inmate, and they ended up using catheters. But in that particular case, if I remember correctly, the court said it was okay to do the catheter until they could figure out a better situation for him. Other courts have similarly said that catheters and urinals are not constitutional violations. And so I don't think that LaFont gets him to where he wants to go. And I don't think it is as strong for him as he thinks it is. And what you ultimately have here is an inmate who, I think the other difference between LaFont and this is a catheter is a much more invasive method than using a medical urinal. A urinal that's being emptied by medical professionals. And so I think that there's a difference there as well. The last thing I will say, Your Honor, is even if we get to the point of you saying, yes, it was a constitutional violation, the way that they treated him while he was in the hospital, it was not clearly established. And I think that these individual guards would be entitled to qualified immunity because it was not clearly established. And specifically, with this combination of factors, given all the other cases out there, that I understand that we really need to look just to the Supreme Court and the Fourth Circuit. And in that context, there were not cases that talk about the use of a urinal. There were not cases that talk about a loud TV. There were not cases that talk about how quickly an inmate can be forced to eat his meals and things like that. And even when you take all those separately, but then combine them, I still don't think that it was clearly established.
All right, thank you.
Thank you.
Mr. Lewis?
Judge Harris, I think you made a really salient point about the curated set of logs. I think it's really important when we're thinking about these inferences that happened in the district court to remember, yes, that's a curated set of logs. In early July, NCDBS had noticed that these things were going on. Those early July dates all predate the creation of the logs that we don't have. And according to what was agreed to in discovery, that's at least 15 days. If you look in the record and you see how many logs there really are, there's really more.
For those 15 days, are there medical records from the hospital?
The medical records that we have from the hospital, there may be, I'm not sure if they match up directly, but they're not really the same thing. These medical professionals are kind of coming in and out. They're worried about trying to fix this complicated issue that's going on with him. The guards are with him all the time. When it comes to thinking about, well, is this curated?
I would think the medical professionals would also be worried about whether he's getting the proper nutrition, whether he's being taken care of, that sort of thing, that would be reflected, as opposing counsel said, in the medical records, correct?
Correct, if they know about it, if they know what's going on. And they may not know all of these things, particularly when opposing counsel was framing the urination issue, said he didn't get to use the restroom in the way that he wanted to. That's not really, I think, a really fair way to look at it. The issue is whether or not it was a wanton infliction of pain to try to degrade and humiliate him when his family's there and when mixed company guards are there, when he's asking, can I just use this restroom that's right here? And they're saying, no, you can urinate in this cup in front of everyone.
Let me ask, I guess on these records, did you, one of the things the district court said is that you didn't establish who was responsible for maintaining them. So in discovery, did you ask them, who's responsible for retaining these? Who do I talk to? Who's the custodian? And if you didn't get those, then did you file a motion to compel? It's just very concerning to me why this issue wasn't presented to the district court in a way that he could have dealt with.
Yes, we did ask everyone. We took about 15 depositions, including some 30B6 depositions, and asked, well, who would be responsible for this? Everyone said, well, I don't know. That wouldn't be me, and I couldn't tell you who.
What, even the 30B6 person couldn't answer that question?
No, and to be fair, I don't know exactly what the 30B6 categories were, but included in all of this, we're asking everyone, including policymakers,
So
wardens.
then did you file a motion to compel?
I believe we came right up to it. I don't know if.
So that's a no?
I'm not sure if it got filed. I don't want to answer yes if we didn't. When it comes to, well, okay, then we're just apparently naming people willy-nilly and we don't know who's who. We actually painstakingly tried to help show our clients what's going on and allow them to try to remember. This is like 4 years later, but they actually were able to specifically remember some guards, and I think it's really important to say that when it comes to the objective level and when it comes to the subjective as well as qualified immunity. I mean, when it comes to the urination, they specifically identified McLam, Burt, Oliver, Royal, Ward, Diggs, and Salas. Those guards variously denied or equivocated on whether they did that or not. It was brought up as to whether those guards were just kind of doing this when there was only one guard in the room, if they had a reason to do it. There's no guard that testified, yeah, that's when I did it with Devontae. Sometimes I'd only have one guard in the room, so that's what I did. A lot of them, most of them, all but one, just denied it. Another guard said that it would be inappropriate to behave like that. So that's not in the record. There's suggestion of maybe that would happen in hypothetical ways, but nobody is saying, yeah, when Devontae needed to urinate and his family was in the room and two guards were in the room, or there was just one guard in the room, and so that's why I had to do it. I did it that way. I'm following policy. That's not in there in terms of a guard on their actual knowledge of what happened saying that. To all that extent, under Peltzer and under Lafott, qualified immunity is all about notice, and these folks had noticed that what they were doing was inappropriate. Even some of them testified that that would be inappropriate. So I see my time is up, and we respectfully ask this court to reverse the Eighth Amendment claim and remand it to the district court.
All right, thank you. We'll come down and greet counsel and go to our next argument. All right, we're ready to hear argument in our next case, United States versus Sanders. Ms. Skelton.
Good morning. May it please the court, my name is Megan Skelton, arguing for the appellant Corey Sanders. In this case, the jury instructions allowed the jury to convict on a standard that was lower than willfulness, and taken as a whole, they were confusing and a misstatement of the law. In addition, the district court improperly interpreted the phrase sophisticated means, which, as we explained in the supplemental briefing, is a genuinely ambiguous term. And so as a result, the district court improperly increased Mr. Sanders' offense level by 2 levels.
And now on the jury instruction issue as being a confusing misstatement of the law, what is the standard of review?
The standard of review is de novo because our argument is not whether evidence supported the jury instruction, which is something that the government argued in its brief.
Wait, but that's, what was the objection below? Where can I find below where the objection was that it was a misstatement of the law?
Your Honor, I believe that it was a general objection to including the instruction
I
at
don't
all.
think so. I think it was an objection that it wasn't supported by the evidence.
Your Honor.
Which would make it plain error review.
Even under plain error, this would still be a reversible error.
Okay.
And that's because it is clearly plain. No court has ever approved this instruction before, and it is a clear misstatement of the law. Willfulness is a well-defined term.
Has any court, you said no court has ever approved this instruction before. Has any court ever disapproved?
Not this particular instruction. This seems to be a very unpopular instruction. However, courts have specifically disapproved of the use of the word irregular with respect to the term willfulness. And that is really what our concern is here, is that term irregular allows a jury to convict based on carelessness, negligence, scatterbrainedness.
But counsel, isn't the same true of secretive? And you're not challenging that, but people can act in secretive ways that are not at all willful. Like, it's not that they know it's illegal, they don't want to violate a company policy, they don't want to get caught by their spouse. So I guess I'm not understanding how you can make this argument as to, I can't even remember it, the thing that is not secretive.
Irregular.
Irregular, thank you. Like, what's the difference?
Well, there's a couple of differences, and irregular is worse than secretive.
Well,
So-
it's, the other way to put that, I think, would be that maybe the inference of willfulness is stronger from secretive than from irregular, but that's like a difference of degree, and it's a jury question.
Well, it is a jury question. I have a couple of responses to your question, Judge Thacker. I agree.
That's Judge Harris.
Oh, I'm sorry, Judge
Happens
Harris.
all the time.
Yeah.
There are a couple of answers. It is a question of degree, but we've got a single instruction that puts these two as equal, and that's going to be confusing when you consider the.
What about the fact that isn't the word "or" between the two words in the
Or-
instruction?
That is correct, or is between them, but it's also kind of clumped together. The other part of my answer is that secretive is less concerning than irregular, but instructions that this court has looked at that, or excuse me, not instructions, cases where this court has looked at the word secretive with respect to willfulness tend to look at sufficiency of the evidence as opposed to the actual instruction. The instruction doesn't talk about secretive, but they look at the evidence of secretiveness. But those are also, most specifically, in sort of structuring or tax fraud, where the secretive conduct is very specifically tied to a specific known legal duty, not simply to the fraudulent intent. So the secretive conduct is linked up with something that would very specifically demonstrate a knowledge that you're acting contrary to the law, instead of simply trying to, do basic deceptions. I was talking about the fact that irregular is itself confusing. We don't know what regular is, and the real concern here is that this instruction would allow a jury to convict on something that we know is not willfulness, which is negligence or.
But wasn't the jury told specifically, this is what willfulness means, and you can't convict if it's just negligence?
Yes, it was instructed on that, and then it was immediately instructed on
Not
this.
immediately, I thought in between. Am I not remembering right? First there's willfulness, then there's that long paragraph about how, like state of mind is not usually something that can be proven directly. Usually it has to be inferred circumstantially from conduct. And then at the end of that long paragraph, you get this instruction that gives some examples of the kind of conduct that the jury could find is sufficient to infer the willfulness that they've already been instructed on. So I think when you look at it as a whole, it actually seems pretty consistent to me.
I disagree. I think that when you look at these instructions as a whole, you've got conflicting instructions that would turn out to be confusing. So yes, I 100% agree that the jury did have an instruction that said negligence is insufficient. But then we have the discussion of willfulness, we have this description, and then when we're talking specifically about fraud, there's another instruction that says misrepresentations alone are not fraudulent intent. You combine all of this stuff, and it's a little bit like a roller coaster where the jury doesn't know which way it's supposed to go. We have misrepresentations, which are surely irregular, are not sufficient. Carelessness is not sufficient, but irregular is. So this leads the...
Well, the instructions don't say irregular is sufficient. They say a jury may infer from irregular conduct the mens rea that's already been described to them. So again, I'm not sure. I agree with you that if the instruction said, if the defendant behaves irregularly, you should find willfulness, then we'd have a big problem, but that's not what they say.
Looking at the instructions as a whole, secretive and irregular are the only specific examples of what would constitute willful what could constitute willful behavior. And so the fact that those are highlighted really amplifies them where there's no other examples given. So again, looking at it as a whole, it's really a problem, particularly since this is a really troublesome instruction. I discussed the provenance of this instruction in the brief, and the case that supposedly gives rise to it doesn't include the instruction, doesn't include any discussion of irregularity.
Is that the case from 1919?
It is, Your Honor. And it's never been cited. I tried both Lexis and Westlaw, and I could be wrong. Trying to prove a negative is certainly difficult, but I certainly didn't find that. This court has, of course, explored what willfulness means over and over and over again. I relied heavily on my brief in Blankenship, which I think is a really extensive discussion of it, and I think it supports this conclusion that multiple things could give rise to the inference of willfulness, but certainly not irregularity. And that case was focused on whether reckless disregard of a legal obligation would be an appropriate definition of willfulness. So it's not 100% talking about this, but that's part of the problem here, is that there really is no case that looks at an instruction like this.
Can I ask, so even if let's just for a moment assume that we would agree with you that there was error in what was provided. The next step, though, I just want to be clear on what your argument is, because you cite Sullivan versus Louisiana, but I don't think you're arguing that this is a structural error. Can you clarify that?
Your Honor, I pointed to Sullivan simply to say that in some cases jury instructions that relate to elements can be. I'm not going as far as that, and I don't think that this court needs to, but it actually would dovetail with a point on whether it's plain error or not. It certainly does impact Mr. Sanders' substantial rights, because it diluted the government's burden on an element of the offense, the intent element, which is, of course, the most contested element. The conduct here, a lot of the facts were not particularly contested. So it certainly does impact substantial rights. The Sixth Amendment jury trial right is about as substantial as it gets.
Can I ask a question about that? And it goes back to the secretive versus irregular thing. I mean, even if we were to assume that the jury relied on this and drew an inference, I mean, all of the conduct in question could as easily be described as secretive, the using of the fake names or email addresses. How do we know that the jury focused on irregular and not on secretive?
Well, that's a real problem. We don't know what the jury.
Right, but if we're under plain error, the burden is on the defendant to show that there was this effect on substantial rights.
These are co-equal aspects of this instruction, and again, as I said, they're the only sort of characterized activities that would allow the jury to draw this inference. So they are given a great deal of weight for the jury. Your Honors, I would like to move on to the sophisticated means argument, but I have actually one small thing to mention with respect to my reply brief. On page 4, there is a typo. I hope it's obvious that it was a typo. It is the forever cringe moment when you prepare for oral argument. I referred to this instruction talking about unconventional or, what did I say? The word is uncontroversial. It certainly should be controversial. But moving on, and I'm sure there are typos in this argument too. I hope that nobody finds them. Both parties agree that the term sophisticated means is genuinely ambiguous. And I will assume that I don't need to discuss that anymore unless you all ask me to. But using that assumption, what that means is that this court has to defer to the commentary of the guidelines. And the commentary is very clear that it's not just sophisticated. Whatever that means, the commentary says it has to be especially intricate, especially complex, and again, does give some specific examples, the shell corporations, the offshore accounts, really next level kinds of sophistication. And this court has not yet addressed that enhancement since Kaiser, as far as I can tell. Again, the court has certainly looked at sophisticated means over and over again, but not in sort of the new landscape of looking at regulations since Kaiser and certainly since Loper-Bright. So some of those cases that talk about sophisticated means might not have the weight.
Well, I don't understand that. If it's, your position is that the guideline is ambiguous, that means we do defer to the commentary. So why wouldn't pre-Kaiser cases, which also defer to the commentary, be precedent?
Some of them do and some of them don't.
We have pre-Kaiser cases saying we refuse to defer to the commentary?
No, but some of them don't address the commentary at all.
Oh, okay. All right.
I've never found a case that this court abandoned the commentary. Okay. I don't believe that happened. But what that does mean is that sort of looking at the timing of the cases, and some of them are before the most recent amendment to the commentary, so some of those cases need to be looked at a little bit more carefully. Like Ginwright, for example, was 2014. That was before the current version of the commentary, although in that case, it does examine.
Assuming that the application of sophisticated means enhancement was error here, why isn't it harmless error, given that the district court very clearly said it would have given the same sentence regardless?
For multiple reasons. First of all, the judge said that he would have given the same sentence, but it wasn't really for multiple reasons. It was really for loss. At the beginning of the sentencing hearing, he discusses loss at length. And then during the discussion of his analysis of the 3553 factors, he reverts to loss again multiple times.
Counsel, I agree with you that the district court sort of had in mind, like the big argument at sentencing was about the loss calculation, but I'm not sure it matters. I think our case law suggests that if a district court says, as this one did, like I think something like, I want to be as clear as is humanly possible.
In the most emphatic
Yes,
terms
thank you.
that I can muster.
Right.
Is what the district court
I
said.
don't care what the guideline range is. This sentence I got to only under 3553A. And he actually specifically says at one point, even if the offense level were, and I can't remember the number, but it's something way under 2 levels down from the one the court was using, I would still come out the same way. And I don't know how we get around that under our case law.
Well, I think that we have to really look at what we don't have to guess what he was thinking about when he says in the most emphatic terms. The government was looking for loss figures that were way higher than what the court ultimately decided. The defense was asking for loss figures that were way lower. This was argument, there was evidence, there was discussion. When he was going through the 3553 factors, saying this factor is how I'm thinking about the case, this factor is how I'm thinking about it, looking at the nature and circumstances of the offense and the seriousness of the offense in particular, which is where you would expect to see a discussion of loss and and also the guidelines, of course, as like the 8th factor. The judge went through all of the discussion of loss as a poor proxy and never referred to either the conduct that was theoretically sophisticated or the sophisticated means enhancement. The guidelines range would have been 37 to 46 months, which is lower, and the sentence was 45 months, so just 1 month shy of the top range, and he went 1 month lower than the bottom of the other range. I think when you look at these and see what he's really thinking about, it's clear this was not something that he was considering when he was talking about, I would give the same sentence. I see my time is 2 seconds from up.
All right, thank you. You have 3 minutes in rebuttal. All right, we'll hear from Ms. Cusson.
Good morning, Your Honor. May it please the court. Evelyn Lombardo Cusson on behalf of the United States. With respect to the 2 issues in this case, if I can begin with the jury instruction issue, as my colleague did, the court referenced this in its questioning. This was really a permissive instruction. The court went to great lengths in terms of the instructions to explain what inferences are and how willfulness is often not able to be discerned from direct evidence. We're often in the situation where we don't have direct evidence of willfulness. And so the court described this and described how the jury could make inferences and said very clearly that it was the province of the jury to determine whether the conduct that the government argued about was evidence of willfulness or not. And so you can find that in the record at pages 1434 and 1435. Judge Berdar says the government asks you to draw one set of inferences while the defense asks you to draw another. It's for you and you alone to draw what inferences that you will draw.
But with this instruction, the jury could have drawn an inference that negligence was enough, and negligence is not enough.
No, Your Honor, I don't think that the jury could have drawn an inference that negligence was sufficient, particularly given the specific instruction to the jury that negligence was not enough. And
you're talking about if you look at the big picture, all of the jury instructions, rather than focusing on just this one that came out of nowhere. Where did this come from? Has any court ever approved this particular jury instruction?
Your Honor, this instruction is a word-for-word instruction from Sand. I can tell you that it is an instruction that we use in the District of Maryland with some regularity.
So in answer to the question about whether any court has ever approved this instruction, I guess district courts in Maryland have. It just hasn't had occasion to be appealed yet?
Yes, I don't think it's been litigated. I think that courts do use this instruction, but it hasn't been challenged. And as the court noted, the issue with the instruction was really the factual predicate for it, whether there was this evidence of secretive.
Which is why this is plain error review versus de novo.
Yes, Your Honor, though I think under either standard, the government should win in this case.
Well, you argued in your brief that the standard is de novo.
Yes, yes, I did, Your
Okay,
Honor.
and is that because, is the government's position that that this objection was raised in the district court, that this was a confusing and incomplete instruction? Or is the government's position that it doesn't really matter if you object on one ground, that's good enough to preserve all objections?
I think I was trying to view it in the light, sort of give some consideration to the defense perspective here, and there was an objection. But really, that objection was to the factual basis and not to the wording of this
Right.
instruction.
And isn't our law pretty clear that you have to object on the ground you want to raise on appeal?
Yes, Your Honor. And if we look, the court's questioning was getting to this, I think. If we look at these instructions as a whole, they comprise 5 pages of the joint appendix, and this particular instruction is 1 sentence. It's a permissive instruction, and it gives some information to the jury about the types of things that they can look at. They're not required to look at, but the types of things they can look at to determine whether someone is acting with the requisite intent. And Judge Berdar says this in the instruction on page 1444. Medical science has not yet devised an instrument capable of recording what was in one's mind in the distant past. And so we have to infer this from the particular circumstances of the case. And there were many examples of this defendant's secretive and irregular behavior from which the jury could infer that this was not a mistake, that he was acting with the requisite intent. And an important fact in this case, which was evidence adduced at trial, was that this defendant began his career prior to forming these businesses. He worked for a government contracting business, ProTelecom, and he was instructed as an employee at ProTelecom about the significance of the representations that one makes to the government and the requirement, the absolute requirement, that in a government contract, the contractor provide conforming equipment. And that was a conversation with the Mr. Sanders' boss that was recorded and played at trial. And so that's further evidence of intent.
You were just talking about, that the defendant acted secretively. I think their original objection, which is that the evidence really just doesn't fit the instruction, probably is the best objection, because it's not really about the defendant being secretive. This instruction is geared towards secretive transactions. Which is to me somewhat different than, the context is probably best used in a banking context where the nature of the question about how the transaction was undertaken, that would speak to intent. Whereas here, while some of his conduct may have been secretive, the transactions themselves weren't in any way secretive. They were done out in the open. I think the combination of all these tends to be confusing. And it is an instruction I wouldn't give, because I think it would confuse the jury. When you look at the harmless error arguments that you make, a lot of, in that context, those cases deal with instructions that weren't given. But in this context, you have a case in which the instruction was given. And so I guess my question is, how do you make your argument regarding what effect this jury instruction had on the jury, given that it's an instruction that was given versus not given?
Well, with respect to the earlier point that there were not secretive transactions, if I could push back a little bit, there were transactions that were secretive. This defendant needed to be a partner of Cisco in order to supply equipment to the government, to various government agencies. And he was removed from the Cisco partner program because he had made false representations to the government, and Cisco found out about it. And so what the defendant did, and we went to some effort to include in the record particular exhibits that were adduced or that were admitted at trial relating to this. The defendant repeatedly endeavored to register with Cisco. And in doing that, he used different names, different addresses, different usernames, and in each of those registration attempts, he was registered for a period of time with Cisco before that company was able to discern that he was Corey Sanders and should be removed from the program. So I would say that those are examples of secretive or irregular transactions, each of those registration attempts. With respect to the question of harmless error as a whole, I think the court can very readily look to the instructions given in this record and the lengths with which the court went to describe what different inferences are and how the jury may or may not draw inferences, and how the court correctly instructed the jury about willfulness. And this, again, was a permissive instruction. The jury wasn't required to do anything with this information. And there are, of course, are other examples of, there are other factual examples which support giving the instruction. The fact that Mr. Sanders dissolved Sandtech and formed Psycor to avoid his negative performance history with the government, the evidence about the contract novation and the change of names, the multiple registration attempts, which I've described, and then, of course, the fabricated documents for the Polycom and Cisco registrations. Mr. Sanders submitted a false document claiming that he was a partner of Polycom and could provide Polycom equipment to the government, and also a false partner certificate with Cisco.
Did any of the attorneys reference this jury instruction in their closing arguments?
I gave the closing argument for the government, and I don't believe that I referenced this instruction, and my recollection is that the defense did not either. And in fact, the jury was instructed first, and then we went into the closing arguments, and Judge Brodar counseled us not to specifically walk through the elements that it was his job to go through and instruct the jury. And so I certainly endeavored to stay away from that. That's, again, my recollection of the trial, Your Honor. Now, with respect to sophisticated means, the parties do appear to be in agreement that sophisticated means is a term of art, that it's susceptible to more than one meaning, and therefore a resort to the commentary is appropriate and helpful. And as the court, in terms of its questioning of my colleague, the court noted, how is the application of this enhancement, even if it was improper, which the government certainly doesn't concede, how is it not harmless? And so I think, again, resort to the record here shows that Judge Brodar was very focused on the 3553A factors. And there was a great deal of discussion about loss and how loss drives the guidelines. And Judge Brodar said at one point in the sentencing presentation that he felt grateful that the guidelines were not mandatory, because he felt that he needed latitude in terms of this case. And so he spends a great deal of time going through the 3553A factors, and that is on, that is on Joint Appendix pages 1720 to 1730. And at one point, the judge is talking about this particular crime and what it is that Mr. Sanders did. And he says at page 1723, if everyone operated like Mr. Sanders, where the only principle was how can I profit from the system, as opposed to how do I comply with the rules of the system and operate in an honest way, If everyone operated in the way that Mr. Sanders was shown to operate in this case, the economy would fall apart. We don't have the means. We don't have enough. There's a bunch of agents in this courtroom, but there aren't enough on the planet to deal with these circumstances. And he goes on. And so he goes through each of these factors in 3553A. He looks to the sentencing guidelines as is required under those factors. And then he says, as the court indicated, he announces his sentence, and then he says in the most emphatic terms that I can muster, this is the sentence that I would impose. And I think, Your Honor, I think Judge Berdar was trying very hard to mirror the language in Gomez-Jimenez, where the court said at page 382, in this case, the district court made it abundantly clear that it would have imposed the same sentence regardless of the advice of the guidelines. In pronouncing the sentence, the court stated, I've considered all of the 3553A factors, and in imposing this sentence, I do believe that I've properly calculated the advisory guideline range. If for some reason someone were to determine that I did not, I announce an alternative variant sentence. Now, Judge Berdar did not cite these cases, but he
So
said,
all of that goes to harmlessness, but
yes.
can we get to, why wasn't this error in the first place to impose the sophisticated means enhancement?
Because the scheme here was absolutely sophisticated, and the court's cases make clear that all you need is sophistication beyond the basic elements of the crime. And we have that, you know, in terms of the submission of,
And how does the commentary help you? Opposing counsel looks at the commentary and says those examples there are next level kinds of sophistication that we don't have, she argues, in this case.
I think the commentary is helpful. The commentary talks about fictitious entities, and we have that here. When Mr. Sanders fabricates a document saying that Psycor is Polycom certified and able to sell to the government, he is representing a fictitious entity.
But isn't that just the fraud? I mean, it just seems to me that if he was gonna carry out this fraud, this is how he was gonna have to do it, represent that he's an agent of these companies when he's not.
He might have to represent it, Your Honor, in many instances. And so we had contracts and agency representatives from all over the government, and some were more exacting than others. So some, he would submit a bid and say, I'm going to provide this new Polycom equipment. And they would say, okay, it has to be new and under warranty. Others who perhaps were more concerned about certain issues, if maybe it is a military contractor, maybe they've had different training, they're asking for a document showing the certification.
So to defraud them, he needed a document.
To defraud them, in order to get the bid, he needed a document.
I'm
But
still not understanding how that isn't just what he had to do to commit the fraud, right? In sometimes to commit the fraud, he needed a document, sometimes he didn't, but it's just what he needed. Oh, are you saying that he submitted the document even when no one asked for it?
no,
Okay.
I'm saying
Then
that.
how is he doing more than what is just the intrinsic in the fraud itself?
Anytime he submitted an invoice for payment to the government and said, I've provided these conforming goods that were according to the Fed bid terms, that could accomplish a wire fraud, right? The submission is using the transmission of sight, sounds, et cetera. It also, it's a false claim and a false representation. He did more than that by
I see.
fabricating these documents.
You're saying that so long as it goes beyond the elements of the crime, like had he committed a different kind of fraud, he wouldn't have had to do this document. He could have still committed fraud without the document. But to commit this fraud, he needed the document.
Well, if we look at, I mean, there were a number
I see
of.
what you're saying, but that seems like a weird way to think about it.
There were a number of different wire fraud counts, and not everyone was associated with a false Polycom or a false Cisco certification. In some, you know, there was a representation that he was associated with Cisco, and that was enough. But what I'm trying to articulate is that he could commit this particular government contracting type fraud without these fictitious entities making providing the false documentation from Polycom with the signature of Barbara Huelskamp from Polycom, or providing the gold Cisco certificate. He could still have gotten those contracts and provided non-conforming goods and known that he was doing that. Because
Theoretically, he could have done that.
Yes, and
But
in
not
some instances
practically.
he did. In some instances he absolutely did, because people didn't know to ask.
So I would have thought that the I would have been looking at like, well, did he hide the proceeds? Did he, everything you're talking about is just sort of the same stuff he did to commit the fraud. Doesn't there have to be something extra?
Well, if we look at the court's case law on this, for example, in United States versus Ginwright, the court said, the court need only find the presence of efforts at concealment that go beyond, not necessarily far beyond, the concealment inherent in fraud. And so all the wire fraud, the submission of the false claim for payment, the submission of a false document, those could be accomplished without the level of sophistication that Mr. Sanders applied here. And so we also have, in addition to these forged or falsified documents, we have other examples here. We have the termination of one business and the formation of a new one to avoid this negative performance history in the government contracting database, FAPIS. We also have the fact that Mr. Sanders used different addresses throughout the United States to make it appear as though his geographical footprint was bigger. Your Honor, I see that my time has expired. May I finish my response?
Yes, please.
And then, of course, we also have variations of the names in the Cisco program, as I mentioned, and the formation of yet another company, a third company, Armonis. If the court has no further questions, we respectfully ask that the court affirm.
All right, thank you. Ms. Skelton?
Thank you, Your Honors. To the question of whether other courts have approved this, if this case or this instruction is being used regularly in the District of Maryland and not being challenged, I believe that should give the court some concern. I'm more an appellate lawyer than a trial lawyer. I don't really know what's happening in the trial world, but when an instruction that is a misstatement of the law is given regularly, that seems like it is appropriate for this court to step in and provide its guidance of what should and should not be the definition of an intent. And Judge Haynes, to address your points with respect to the government's argument regarding harmless error, when they are looking at the absence of an instruction, it is a very different situation than here, where an instruction affirmatively misstated the law on an element of the offense, which is a far more serious issue. Talking briefly about the sophisticated means enhancement, first of all, one thing that I think I really need to say is that a false document in and of itself is not sophisticated. And that is, as you mentioned, Judge Harris, potentially just the part of how a misrepresentation is made. Another thing to look at is the particular false documents in question, which were extremely rudimentary and did not even necessarily say what the agencies were looking for, might have, in some instances, had the wrong level of partnership, gold instead of silver, or I'm not quite sure, I don't remember exactly the words, but they were false, but not even false enough to have succeeded. This is something that is a second grade project on Adobe right now. This is not a sophisticated thing. I also take issue with the fact that Sycor was a shell corporation. It absolutely was not. It was doing business. A shell corporation would be simply for the purpose of hiding transactions and not conducting business. Now, there's also nothing hidden, or certainly wasn't offshore, certainly wasn't shell. But Mr. Sanders' use of Sycor was as open to the government as it could be. When he was trying to get a contract transferred from Santec to Sycor, he couldn't get the paperwork right, and the agency helped him. They went to their lawyers to help say, how does he need to fill out this form? Then they funneled that information to him. He was not hiding anything.
Counsel, can I ask you a question? I'm sort of genuinely perplexed. You know, we've said a number of times that for the enhancement to apply, there has to be something more than, not a lot more, but something more than what is intrinsic in fraud itself. And I understand your colleague to be saying we almost do like a categorical method thing, just look at the elements of fraud. And if we can imagine someone's conduct satisfying those elements, but without, say, fake documents or a second company, then we're good. Do we look at whether it is possible to accomplish a fraud without these methods, or do we look at whether it was possible to accomplish this fraud without these methods?
May I answer, Your Honor?
That is why I asked.
I think it is neither, to be honest.
Okay.
And this is in deferring to the commentary, which very explicitly says we have to look at the defendant's conduct to determine whether the conduct merited a sophisticated means. So that means that the offense and the elements and even the factual scenario, that is not the question. The commentary is very specific that it is what the defendant did. So it's not, in a hypothetical world, how could this fraud have been committed, because there's infinite, theoretically, number of ways. And we know, deferring to the commentary, that is not the analysis. The analysis has to be what the defendant did in this specific case. And so what that means is, looking at that, we need to look at this relational issue. Is it especially complex? Is it especially intricate? Not, did you have to do this necessarily? Because that's where, for example, Adepoju goes, where a false document in and of itself is not necessarily fraudulent.
Did that answer your question? Yeah, all right, thank you. And thank you, Ms. Skelton, for accepting this court-appointed appeal. We appreciate your service on behalf of the court.
Thank you, you're
Thank
very
you.
welcome.
And thank you, Ms. Cousin, for your able representation of the government.